Good afternoon. My name is Joe Moore. I'm from Tiffin, Ohio, northwest corner of Ohio, and that would be relatively insignificant except that your next speaker happens to be from the same community. I have known Rodney Biggert for a good number of years. I first met him when he was the SSA for my son. I have an adult son with disabilities. And Rodney has career-wise moved up. He is now the Director of Adult Services for the program in our community. In Ohio, services for folks with special needs are delivered through county boards of DD. And Rodney is the Director of the Adult Program. He is also the liaison for Seneca Riad's Industries in Ohio. Seneca Riad's provides employment opportunities for approximately 200 adults with developmental disabilities in our community. In 2015, Rodney and Seneca County found themselves at the center of a national debate over the utilization of the 14C certificate. Mr. Biggert believes that the elimination of the 14C will take one very important option off the buffet table of services available to folks with special needs. He continues to fight for special minimum wage certificate and choice in both residential and day services in Ohio and across the country. We'd like to ask you to welcome Mr. Biggert.
Oh, sure. Is it? Oh, okay, all right. You're acting like that's a deterrent. She said they're going on the website. I'm like, you're acting like that's some kind of deterrent. Is this the clicker that's going to move my things forward? Or, okay. Yeah, we'll give this a shot. Let's go for it. I am super happy to be here. I want to thank Together for Choice for asking me to come and share our story with you guys. I have to admit, when they asked me to come and share and cram the last 3 years of my life into a half an hour, I thought, yeah, I'll take that challenge. If some of you have heard me kind of do this before, you'll have a great chance to critique me because I'm going to try to do it twice as fast. It may be a little tight, so it may be tough for questions, so I will try to field what I can, and we'll just kind of keep it moving and keep it going. Boom. All right, the regulation. So we're here, I'm here primarily to talk about 14C and its application. And so I'm going to read the portion of the act that really applies to what our case was about. An individual whose earning or productive capacity is not impaired for the work to be performed cannot be employed under a certificate issued pursuant to this part and must be paid at least the applicable minimum wage. This is an incredibly important statement, and it's one that affects all of the people who are working with these certificates in this country today. I like to see myself as someone who tries to support people to reach their highest potential. You all do that too. This is a tool that helps us get there at times, and it's certainly under attack. So, kind of our history, obviously Disability Rights Ohio comes back into the mix for the second time today. They've been very busy in Ohio. And so in 2014, Disability Rights Ohio was traveling the state touring both residential and day habilitation programs, just taking tours. In November 2014, they toured our facility in Fostoria, Ohio. We actually have two facilities, one in Tiffin and one in Fostoria. And shortly thereafter, they began asking for payroll records for 3 individuals that were employed by Seneca Riad Industries. They had us sign releases for them and then began asking for payroll records. So that was, try to keep the dates, 2014. So how we got here. In January 2016, a hearing was held regarding the petition for review of wages. An administrative law judge for the Department of Labor heard this, I don't want to say case, it was more of an administrative proceeding. The petition was filed by Disability Rights Ohio and the National Federation for the Blind on behalf of the 3 individuals working for Seneca. And this petition is a little used provision of the U.S. labor law. In fact, it's only been used about 3 or 4 times in the last 30 years. But this isn't like a normal lawsuit. In this case, you are not innocent until proven guilty. In the petition for administrative review, you as the employer carry the burden of proof to prove you've done everything correct under the statute. So, in November 25th of 2015, counsel for Seneca secured Mark Knuckles of Mark Knuckles Associates to review our procedures and testify as an expert witness. Of the people currently in attendance today, how many people are familiar with Mark Knuckles Associates? Good, a great many. He is the expert when it comes to 14C compliance in this country. And so I want to say that first and foremost. He is the expert as far as compliance goes. Try to Google it. Google compliance for 14C. His name's one of the only ones that comes up. So December 14th through the 18th, 2015, Mark Knuckles worked with Seneca Riyadh reviewing time studies, reviewing standards, and reviewing procedures. They began asking for records in 2014. They filed the petition right before Thanksgiving 2015. So they prepared their case for a year. But because this is an administrative proceeding, it's supposed to be an expedited proceeding. So we were in court the first week of January 2016. So they prepared their case for a year, and we had 6 weeks to get ready with Christmas and Thanksgiving and New Year's in the mix. It was a very, very busy time, to say the least. So the result, the ALJ decided that the Seneca had not proved that the petitioners were, and this is a phrase that haunts my nightmares, disabled for the work to be performed. That is the linchpin in our entire proceeding. Disabled for the work to be performed. So because they were not disabled for the work to be performed, the 14C certificate did not apply for these 3 individuals. The ALJ ordered back wages and attorney's fees in excess of $300,000. That's actually a lot less than the petitioner's counsel asked for. They asked for over $400,000 worth of legal fees alone. And the ALJ his order redefines how the industry should look at disabled for the work to be performed. If you can't prove that, you can't use the certificate. It's that simple. You know, it doesn't matter whether your time studies are good. It doesn't matter what their diagnoses are. None of that matters because you can't use a certificate if you don't at least get past that burden of proof. So, the ALJ, I put some quotes up. I want to read them to you because I really think that this is where, the quotes from his decision is really where you get where this thought process is coming from, where the attack against the 14C certificate is coming from. So the production studies in and of themselves, he critiqued our time studies and said he didn't like them for the following reasons. A, they consisted of starting a stopwatch. B, counting how many jigs passed a given point in a given amount of time. And C, performing a few simple calculations to determine how many jigs per hour were being produced by the person being tested. Now, I don't know if any of you have ever done any time studies, but he didn't like our time studies because time studies. Because that is literally the definition of a time study. He also said, I nonetheless conclude that to the extent that such work is available, the employer is required to allocate work in such a manner that as many employees may earn as minimum wage as frequently as possible. Does anybody know where that's at in the regulation? That's because it's not in the regulation anywhere. There is no provision in the regulation that says an employer has to try to get employees engaged in the work in that manner. But he believes we should. He also said on the record before me now, and this one's my favorite line in the entire thing. It is on page 35, I believe, if that lets you know how often I've read it. On the record now before me, it would be pure speculation to conclude that the petitioners don't meet the production standards solely or primarily because of their respective disabilities. It is just as likely that they don't meet the production standards because they are bored with the highly repetitive task that they have performed on 100 prior occasions, or because they lack the substantial economic impetus to perform at a higher level, or because they self-identify as individuals whose performance should be lower than that of their non-disabled supervisors. So, the question becomes this: if it is your job to prove that their disability is impeding their productive capacity, how do you prove they're not just bored? How do you get past, well, they're just bored? It's become, there is no real objectiveness to any of this. And so that's where we've been stuck. So we decided to appeal. Seneca appealed the ALJ's decision to the Secretary of Labor, and that case was delegated to an administrative review board to be heard. In January of 2017, keep in mind, keep our dates here, we got the ALJ's decision on February 1st of 2016. We got the Administrative Review Board's decision almost a year later. They affirmed the ALJ's decision in terms of definitions for disabled for the job, but stated that the ALJ would have to recalculate back wages at the federal minimum wage. The back wages that he calculated them at the Ohio minimum wage, and they claimed that because he was a federal judge, he did not have the authority to award the Ohio minimum wage, and asked for him to recalculate the wages. The ARB also affirmed that the General Fair Labor Standards Act statute of limitations does not apply in an administrative petition case. So if they were to sue us in court, there's a statute of limitations as far as how back they can go to ask for back wages. What they said is in this petition for review, there is no statute of limitations. So, but they also, we did win a concession in that the ARB said that attorney's fees could not be awarded in an administrative petition process. So we dropped from nearly $300,000 to about $30,000, if that lets you know how much they asked for in legal fees and costs. So this has been an animal of a case. So that was the appeal. The Administrative Review Board also gave some rationale for why they agreed with the ALJ's decision, why they decided to agree with this notion that we hadn't proven that these individuals were disabled for the work that they were performing. And they came up with the following. They stated that in this decision, and we've heard this first part we've heard, for any given disabled person, there is almost certainly some jobs for which that person would not be considered a worker with a disability. I mean, we've heard that. They've told us time and again, there's a job out there for everybody, right? But we've heard it. Whether we agree with it or not, we've heard it, right? There's a job out there for everybody. The second one is almost more concerning for us, though. The ARB decision went on to say that there are some jobs for which a worker with a specific disability would never be considered a worker with a disability. Now, it's a little convoluted, but let me walk you through it. They use the example that a blind individual could never be considered disabled for the job of musician, judge, writer, mathematician, or politician. This is because many blind people have been able to excel at certain careers. They literally used, Stevie Wonder as an example of how, you could never be disabled for the job of musician. They also went on to state that someone with Asperger's syndrome would not necessarily be disabled to be an actor, singer, scientist, or economist. Again, because people with Asperger's syndrome have excelled at those careers. So think about that for a minute, though. For those of you who do day program, for those of you who are using a 14C certificate now, think about that from this perspective. You set a standard. under this variation or this interpretation, if someone with Down syndrome were to hit your standard and start making the commensurate wage, the prevailing wage, then Down syndrome does not prevent that person from being able to hit the production standard for that job. Therefore, no one with Down syndrome should be able to have commensurate wages under the 14C certificate for that job. That's what we're up against. That's the definition, at least the way it's being defined now by the Administrative Review Board. Seneca argued that there is no guidance on how to determine if an individual with a disability is a worker with a disability, and we utilized the Field Operations Handbook that DOL gives to its investigators in the field. The Field Operations Handbook as our proof. In the Field's Operations Handbook, it tells their investigators in the field to go into a place, spot check the disability record, and then check the time studies and observe the individual at work. Observe their production capacity. That's exactly what we do. Their response was, the underlying premise that the regulation and the non-binding, suddenly non-binding, Field Operations Handbook lack detail in how an employer is to establish that a worker is a worker with a disability is, again, impaired for the work to be performed. They're correct. Seneca is correct here, but this does not help them. So we're correct. There is no way to know whether you're doing it right, but guess what? That doesn't matter. While the ARB agreed with Seneca's agreement, they stated that a lack of detail in the regulation in no way obviates the requirements that an employer must demonstrate that a person is disabled for the work to be performed before it can pay that person less than the minimum wage pursuant to a sub-minimum wage disability certificate. Here, Seneca Riad's has failed to meet the burden to show that it satisfied that requirement. So sure, there is absolutely no way for you to know how to do it, but you still had to do it before you had the ability to pay, even though you went through the steps of getting the certificate. This is a large gap in this system, in this 14C animal. And in fact, later on, the ARB does say that the secretary should devote some time and resources to coming up with guidance to make sure that other employers are doing it and doing it correctly. But again, sorry about your luck. You know, you didn't prove it. And so here we are. So the next steps, Seneca appealed the ARB decision to the United States District Court for the Northern District of Ohio, Western Division. In the meantime, DRO filed a second lawsuit to retrieve back wages that they believe were not covered by the ALJ's decision. One thing they called the gap period, and this is the period that compromises the date between the actual award. Before we went into the hearing, they asked for all the wage records from, I believe, December of 2015 through December 27th, or no, back to December of 2012, 3 years, and that was the award. But we went into court on the first week of 2016, and we didn't get the judge's decision until February 1st. So for 30 days, we were still paying commensurate wages, and they didn't have wage records for those. So they were saying that there's a gap period, and they wanted to file a second lawsuit to get those, which was not very much money, and to go into a lawsuit for such a small amount. Our argument back was the ALJ's decision said that we didn't have the ability to use the certificate. Therefore, that gap period would already be covered by his decision. We argued there is no gap period. We'd obviously owe those wages as well. The Department of Labor filed a motion with the federal court asking that our appeal be dismissed. The claim was that our current case was not ripe for appeal. They stated that because the ALJ's decision had been remanded with respect to the recalculation of the damages, there was no final agency action. And until you had a final agency action, you couldn't appeal their decision. case law states that these ministerial calculations, these small things within the case, that's not what we were appealing. We were appealing the decision itself. The calculations were immaterial to the decision. The decision was what we were trying to appeal. So we argued that we should still be able to file that appeal. And that's still ongoing. In accommodations, starting in August of 2017, Disability Rights Ohio started asking for a number of workplace accommodations, claiming that Seneca needed to provide these under the ADA. So, it was full court press, but, it's been almost 3 years now. I think they really thought we'd be done. But it was, so let's throw a second lawsuit at them. Let's start asking for accommodations. So we've been working our way through that. We do know that they're working against other providers in the state of Ohio right now under just that same premise, that they're not providing appropriate workplace accommodations for the people that they serve. The recalculation in April 2018, the ALJ contacted both DRO and Seneca's attorneys to determine whether to reopen the record and calculate potential back wages owed to the petitioners, including back wages back to their initial date of hire. This is because the ALJ and the Administrative Review Board decided that the statute of limitations did not apply. The ALJ stated that there was a gap period and that his decision did not cover that period because he didn't have the payroll records for it. So he wanted to address that gap period as well. The hearing for reopening in June of this year, a hearing was held to discuss whether the ALJ should reopen the record to allow for these additional back wages back to the initial date of hire. This means that there is the potential to take any employee we serve, file one of these petitions, and if you can't meet the subjective nature of this test, a test that they haven't told us the answers to yet, that your potential liability could be minimum wage back to initial date of hire. I've got some people who've been working in our facility for more than 40 years. We do good things. This isn't about wanting to take advantage of anyone. I'll be honest, it's not really about the wages. Now, don't get me wrong, I didn't want to pay all the attorney's fees. But if it had just been the attorney's fees that had fallen off, we'd probably be done. But it's this definition. It's the definition that will make it nearly impossible to do what we do. And so we continue to fight. And I'm running around trying to educate people because I don't know that people know. So the ALJ decided that due to the statute of limitations not applying, that he was awarding back wages all the way back to the initial date of hire. Seneca has appealed that decision. Back to the Administrative Review Board we go because it is different than his initial decision. So instead of being able to take our case to the federal court, we have to go back through the ARB process. And so we wait to hear how they're going to address this remand. But it leaves us with some bigger questions. What type of medical or psychological evidence would be necessary to prove that it is the disability that is hindering their job performance? That hasn't been addressed by anyone at this point. And we've been at this for this was 2016 was when we had the hearing. February of 2016 is when we got the judge's decision. It hasn't even been addressed as to what could have been done to prevent this. How would any employer ever prove that an individual isn't just bored? I don't know the answer to that. And does this standard make it nearly impossible for well-intentioned people to utilize the 14C certificate? And if that's the point, then this is a coordinated attack to take a valuable tool off of the buffet of services for the people that we support. And so I fight on. Thank you.
So we have about 5 minutes for questions. Does anyone have a question?
So I've got to ask,
Let me move over here.
two employees, right?
Three.
Did they have any interest in the pursuit of this, they and/or their families?
There was no real family involvement. I do believe that these people were already working with DRO on other cases, and so I think that they just decided to expand it to our issue as well.
But did the gentleman or workers pursue it, or?
That's a great question.
Right,
I don't necessarily
know.
know the answer to that.
Okay.
I know they participated. They participated, but I don't know if it was their pursuit that caused it.
I think another issue that we have to address is the letter that went to the Senate from Senator Elizabeth Warren, dated April 23rd, 2018, about the 14C.
Absolutely.
And it's signed by not just Senator Warren,
I believe Senator Sanders
Senator
is on there.
Casey, Senator Patty Murray, Senator Chris Van Hollen, Senator Margaret Woodhasson, Senator Duckworth, and Bernie Sanders.
Bernie Sanders as well.
So now they've already been given the Kool-Aid.
Oh, absolutely. I think a lot of
So
people
now how do
have.
we address them?
If anybody's gotten in, we'd gladly take it. I agree with you. I think there's going to need to be a coordinated effort because I think I agree with our last speaker. This is going to have to be, Congress is the only one who can necessarily make that change, but the fight is on. And so my question is this a judicial road to making something that's still legal through statute impossible to do?
How does this affect, I'm assuming that work came to your place. You did time studies and individuals that were there did this work under 14C. Does that stop companies out there across the nation from doing work with places like yours?
I do think that we've been blessed. Our partner in our efforts to create that work environment have stuck with us through this. So we've been very lucky, we've been very blessed, but it's been a very close relationship. We've worked with that company for over 30 years, so it's something we've been able to forge and make something great out of. But I could see this being a real issue, and I do believe that the P&As, especially looking at other things that are happening in Ohio, are targeting the actual the vendors that we contract with, the contract, that we bring in. They're going after that entity now as well. We've been lucky at this point.
Could that have been I heard a little bit about this case. Would one of the individuals' mother an attorney helping in this?
I am not exactly sure on that case who the attorneys involved are, but I know the ins and outs of the case a little bit, but I don't know who the attorneys are.
Thank you.
Hi, Caroline Larman from Ohio. When I'm hearing you speak, and you've done a great job explaining this to us, what's going through my mind is that they're having you jump through hoops to prove impossible things, and they're putting you in a box. And they're not receiving any other inputs except from you. It's kind of you against them, and it's an impossible situation. I personally think what needs to happen, and I don't know if this is appropriate in terms of this particular lawsuit, but what we did in our lawsuit was we got other family members to speak up in addition, so you're not the only voice saying this is absurd. So to what extent are you reaching out to the other families in Seneca County, saying send letters in, try to intervene, do other things to show that these interests are not representative of the entire population?
We've done a great job at working with our congressional representatives and our Senate representatives in Ohio. We've held kind of like dinner and dialogue style events where we have 300 people show up, you know, family members and individuals with developmental disabilities, the people that we serve and their families and other stakeholders in our community who see the good things that we're doing, had a video conference with one of our congressional representatives to talk about how we wanted to make sure this stays a viable option for people with disabilities.
Yeah, but what I'm talking about is, sorry, thank you. Just a moment, sorry, thank you. Is inputs directly to the ARB in sort of testimonies directly to them, you know, where they are having to respond to this and justify their actions to the broader public. Right now, they're not having to do that.
Yeah, right now
they're in a cocoon of the court.
Yes, yeah. We have toyed around with the idea of having a friend of the court brief done by the families and other people who have vested interest in this decision moving forward. So that is something that's on the table.
That needs to be done as soon as possible, I believe. That's my personal opinion.
I'm Jeff. I'm a resident here at Misericordia. And my question is, we're all here to talk about choice. And the choice of living and working, being here at Misericordia, and being a successful ambulatory here. And it's just, you know, Misericordia is just a wonderful place. Am I right, guys?
Oh, it is. Absolutely.
And I just wanted to say, in the choir, we went to Navy Pier and procure. And the thing of it is that we all have choices in our lives. And the best choice of all is choosing Misericordia as a big facility because it's a great opportunity for people with individuals to have a place where they can call home. And that's why I want the state to recognize that we have a place that we can call home. And I don't want anyone to help. I want everyone in the state to realize that we need help here. We want everyone to come in and say, Misericordia is the best place for any people with intellectual disabilities to move here to Misericordia and to open up the wait list because we're waiting for other people to come in. And the reason why, because of that, is because we all know what the mission here of Misericordia is all about. It's about the heart of mercy.
Absolutely. Absolutely.
First of all, I want to say that I'm sitting here and I'm just frankly appalled.
Sitting where?
I'm right here.
Okay.
I'm right here. Here I am.
I'm sitting here. Sitting where?
Yeah, I'm sitting here and I'm very
Gotcha.
shy. So, what? We're done? Okay, never mind.
Well, I will be around, so if people have other comments or
Okay.
questions, I mean, usually I knew this was going to be crazy. So if you guys got other questions or comments, please stop me. I'm going to be around. So thank you guys. Thank you very much. Thank you.